Welcome to Employment Law This Week. I'm George Whipple. The United States Supreme Court rules Title VII's prohibition of sex discrimination includes discrimination based on sexual orientation and gender identity. In a consolidated opinion addressing three separate cases, the court held that when an employer fires an individual merely for being gay or transgender, that violates Title VII. This landmark decision resolves a split that had developed among the circuit courts of appeal regarding whether Title VII's protections against sex discrimination apply to claims of sexual orientation and gender identity discrimination. The decision will have a broad impact, given that the majority of states do not currently ban discrimination based on sexual orientation or gender identity. President Trump's first Supreme Court appointee, Justice Neil Gorsuch, wrote the majority opinion in the 6-3 ruling. Gorsuch writes that an employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. Lengthy dissents by Justices Alito and Kavanaugh note that the decision could have unintended effects on issues such as health care benefits, bathroom and locker room access, dress codes, women's sports, and hiring by religious groups. The EEOC says employers cannot refuse to let older employees return to the workplace simply because of their age. With so many businesses in the initial phases of reopening, the EEOC released a new set of FAQs to address employers' concerns relating to higher-risk employees. The Commission made clear that automatically excluding older workers from the workplace would violate the Age Discrimination in Employment Act. However, the EEOC confirmed that, while there is no right to an accommodation under the ADEA, an older worker with a serious medical condition who is reluctant to return to the workplace may be entitled to a reasonable accommodation under the Americans with Disabilities Act. If the employee requests an accommodation, the employer must engage in an interactive dialogue with the worker to determine if a reasonable accommodation, such as telework, is available and would not cause undue hardship. The FAQs included a similar analysis with respect to pregnant workers returning to work. And that's it for this week. Thank you very much for watching. Stay safe, and we'll see you next time.